contracting for the Infrastructure Delivery Division at the Development Bank of Southern Africa, where she joined in March 2020. Without wasting much time, please could you put your hands together for Gabriela?
Good morning, everybody. We don't have the topic for our panel discussion this morning is the problems within the JV on African infrastructure projects and what to do when the relationship breaks down, or in what instances do we have the different scenarios of where we call that the relationship breaks down. From my side, I have the benefit of having been involved in mega projects, working with multinational contractors for a state-owned employer, and I've also had the benefit of working in social infrastructure projects, with much smaller contractors, very different funding, very different makeup of contractors. So I thought it would be beneficial for our colleagues to highlight what are the two different ends of the spectrum when it comes to joint ventures and contractors. So on the one side, as far as social infrastructure projects are concerned, so we're talking about the building of schools, the building of hospitals, road projects, infrastructure projects like sewage plants, water treatment plants, smaller projects. You usually are faced with contractors that compete for lower value contracts. So in my experience, you're talking anything between $300,000 US dollars to 15 million US dollars, as compared to when you are engaging mega projects, big infrastructure projects, power stations, mines, huge road, inter-provincial or inter-border projects. Then you're talking about projects 10 million, 100 million US dollars and up. And that brings its own different scenarios when it comes to joint ventures. On the one side, you have inexperienced contractors, mainly your small to medium enterprises who've entered the market not so long ago, who are maybe one or two owners and have a very unstable workforce, as opposed to your multinational, highly experienced contractors with established reputations, with established skill set, and that is what they bring to the project. When we talk about joint ventures competing as part of social infrastructure projects, because of the value of the project and not the lack of complexity, but because it's mainly bricks and mortars, a lot of civil work, you have a large number of competitors that will compete for that kind of work. So what you would find is that the work is very is not as technical as many of your high value mega projects, and therefore, to the extent that a smaller project requires any specialized skill, the contractor would subcontract that, and would end up subcontracting their electrical, they would end up subcontracting their mechanical works, if not subcontracting, becoming joint venture partners with another party that can provide them with that kind of skill. As opposed to with your multinational and bigger construction companies, many times they would form joint ventures with the strategic partners that they would have already had relationships whereby they would have worked in projects all around the world. Sometimes they might be the OEM of the project of the equipment, and therefore they might subcontract with another SPV division with a whole different types of expertise. So it's much more structured, much more sophisticated. And that also brings some kind of quality control and security of supply from an employer perspective. So at each end of the spectrum, so on the lower end of the spectrum, your joint ventures for your lower value projects bring different set of risks. And at your higher end of the spectrum, your joint ventures, albeit with multinationals, will bring a different set of risks. So just to carry on that line, what we also see with joint ventures in your lower spectrum is that they are not business savvy in pricing a tender. So many of these entities either price very low because they know they are competing with a high number of competitors in the market and they want to get that tender. So they would price very low to their own detriment, or they would price incorrectly. And they don't know how to make up their P's and G's, so they don't know how to make up the different aspects of a bill of quantities, or even if it's lump sum, they wouldn't, they lack the experience in dealing with a partner and allocating risk appropriately. As opposed to when you look at mega projects and dealing with multinationals, there's a lot of great business acumen there, and they would know how to price a contract, depending on the set form of contract. So your experienced contractor would price a FIDIC rate book very differently to an NEC contract. And that's something, that kind of sophistication is something we don't see with your smaller emerging contractors and emerging joint ventures. One key thing whilst the project is in construction is that your smaller contractors, because of the lack of commercial acumen, they miss out on many opportunities to submit claims, and to maybe challenge the employer in terms of potential variations. So depending on the set form of contract they're working with, they might be time barred because they don't have the back office staff to keep the records and to submit claims on time. And if they submit claims on time, they may lack the substance required under contract to successfully prove those claims. Unlike in the opposite side of the spectrum, you'll find that your big construction companies have a huge back office support. They've got contract specialists, they've got commercial specialists that on a daily basis keep records, look for opportunities where to claim, even vexatiously, if I may say so, just to, if they submit 100 claims, maybe 60 will be successful and they would have done their jobs. So that's where you would see your joint ventures at the different end of the spectrum bringing different risks into a project. So when we talk about different risks, sometimes the theme may be the same, but the actual risk, the degree of the risk may be different. So for example, quality of work with an inexperienced or a smaller contractor, you have a lot of rework to be done, for example. So you would demand or instruct the contractor to do rework. That wastes a lot of time, which has an effect on your completion date. Similarly, after takeover, after the project is being completed and you're into a defects period, you may have a scenario whereby the contractor takes a long time to fix those defects or simply doesn't fix the defects, and it leaves you with, if you were able to get some retention money and use that money to fix those defects. Sometimes, depending on the nature of the project and the nature of the industry, with the smaller projects, you don't have an opportunity to have had a performance guarantee or a retention guarantee, unlike in your bigger projects where ordinarily the market will dictate that as part of that tender, you would have a whole set of security. Your performance guarantee, usually anywhere between 5 and 15% of the contract value. Your retention, either in cash or as a form of a guarantee. In the context of big multinational companies, in many instances, the employer would require a parent company guarantee. Now, in the context of joint ventures, it becomes interesting because in the context of joint ventures, how does an employer protect itself in terms of guarantees? Do you ask a guarantee from every joint venture partner? Do you ask for a guarantee as a joint venture if it's an unincorporated joint venture? So it can get a little bit complicated, but there are solutions for all of those complexities that arise. Cash flow is a big theme that, although it might be a common issue between both parties, it's treated differently with a smaller joint venture. Cash flow becomes a key issue for a smaller company. Some construction companies, as you may know, function on a month-to-month basis. And if they come short in a certain month, they're not able to pay labor, they're not able to pay the joint venture partners, they're not able to pay subcontractors. And that may cause huge delays in the project. It may cause instability in the project because you have your labor potentially striking, demonstrating in some form of other, as opposed to your joint ventures that are more solid in respect of cash flow. Your bigger companies that have a big balance sheet in which to fund, in some ways, the project. In many instances, the cash flow leads to abscondment by many contractors in projects. They feel so much pressure from their own laborers and partners, and they don't have the money to pay, particularly if the employer is late in paying, that you have contractors leaving site, absconding, and delaying your project. Now, if the employer is a government institution, you then are found in a situation where you are going to be further delayed because you have to follow a process to bring somebody new in. So that's the theme that cash flow can, those are the issues that cash flow can bring. Something that Prof and I were discussing earlier, and we're discussing with another colleague as well, is community impact. And community impact can have different scenarios depending on what kind of projects you're working in. So for your social infrastructure projects, a lot of the time the community is really excited to get a new school, a new hospital, a new water reservoir. But depending on your leaders in that community, there may be some jealousy depending who got that contract. And you may find some kind of social instability because the local community is not happy that one of them didn't get the contract, or enough of them are not involved in the project. In my experience in South Africa, we have a lot of that, particularly in the KwaZulu-Natal region, in which factions are very tribal, and the Zulu tribe is very it's predominant in that region, and if they don't get piece of the pie, there's a lot of vandalism to critical projects in the community. And we're talking about schools, we're talking about hospitals that are needed in that community. But because they don't see the personal impact financially, we get a lot of disruption. And in that instance, it is important for employers to look at potentially mandating JVs. And what I call mandating JVs is that there has to be a partner of that JV from the local community. And in that way, you kind of mitigate the risk of this community factor that it can be so prevalent in social infrastructure projects. Unlike in bigger mega projects, you have the community acting in a different way. Sometimes the community feels threatened by a big multinational coming in and potentially affecting the environment, affecting the national habitat. So the role of the community with bigger projects is different. But I think community influence is ignored many times in many of these projects, whether it's big projects or small projects, whether you're working with big contractors, small contractors. I think employers need to pay much more attention to your potential community impact and find mitigating factors to make that project successful. My last two slides deal with common risks in respect of, so whether you are a big multinational with offices all over Africa as a construction company, or whether you are a small emerging contractor, there will always be issues in the joint venture relationship if the joint venture relationship is not clear to all the parties. So in my experience, usually after the honeymoon period is over, I mean, the honeymoon period, you are so happy, you won this tender, you're going to make so much money, and then 2 or 3 months into the project, you realize is not as you thought it would be. And usually, if the documents and the understanding is not aligned, that's where you find this honeymoon period coming to an end very, very quickly. You usually see that where there is a number of JV partners and the split in not only responsibility and profit is, you know, somebody's 50% into the JV, another one is 20, and then you get 5, 5, 5, 5. Those minority shareholders become very disgruntled when they've cashed in their share of the JV, and then for the 10 months left in the project, they get nothing, for example, because there was a different expectation. So making sure the JV partners have a clear expectation up front is key to the success of that relationship. Sometimes with bigger multinational JVs, you find that they become so hungry for profits that they are commercially very aggressive. And what do I mean by that? That they try to claim for absolutely everything. I mean, I had an instance where a joint venture of a German and Japanese company claimed force majeure for an earthquake in China. And I'm like, okay, please explain to me, like a 2-year-old, how does this affect you, right? So it is a question of becoming commercially aggressive, and that can sour the relationship between contractor and employer. As I said earlier, you know, unclear JV roles. Many JV partners believe they're subcontractors or vice versa, and there's not a clear allocation of roles and responsibility under the JV agreement. Naturally, as the employer, if you are contracting with a joint venture, you don't want to know really much how they arrange their own affairs because you would want to contract with them jointly and severally liable. But it's important to raise the flag early on and say, guys, know what your role is within the relationship. Don't come to me as a minority partner in a joint venture a year later and want to claim on your own, want to submit a claim on your own, or want to do work on your own, because that's not going to work. A lot of the time in these joint ventures there are 3 to 4 partners. Once a joint venture partner has finalized its share of the job, they want to exit the joint venture because they don't have any further benefit. Be careful with that. Make sure that your contracts hold every joint venture partner jointly and severally liable because you have evaluated that joint venture as a whole. Don't rely on the reputation of one joint venture partner. Look at them as a whole. And that also leads to, you know, a rogue JV partner, somebody who didn't understand the relationship, is unhappy with the lead partner of the joint venture, and then wants to go rogue and go to the employer and bring the joint venture into disrepute, you know, tell stories about the lead partner and why I must claim now and why he hasn't claimed on my behalf and all sorts of things. These things here, I find in my experience, are very common, either with big multinationals or with your smaller inexperienced companies. And my personal view on why this is like this, I think it's because it's human nature. We're dealing with humans, right? So humans, whether educated, non-educated, sophisticated, not sophisticated, rich or not rich, will always find conflict when there's something at stake. And I think when it comes to joint ventures, it's always advisable to ensure that as an employer, you make the rules of the game clear from the onset. I think I've got a mitigation clause, but I think slide, but I think that goes into your disputes, Prof. So you can deal with that then. Thank you. Do you want to take questions, or how do you want to? At the end.
Yeah, after the session. Thank you very much, Gabriela. Very quickly, we would have Ren Koopman come up next. Ren is a... Anyway, I think let's just continue with the physical event, and the virtual audience will join us eventually. Ren Koopman is supposed to be online. So, Prof. Oh, I think we still have Ren. So let me introduce Ren very quickly. Ren Koopman is a civil engineer with 25 years of construction industry experience. He's worked in the UK for 13 years for two tier one contractors in quantity surveying and commercial management roles. I understand that Ren will be speaking on problems within the JV on African infrastructure. Over to you, Ren.
Okay. Hello, everybody. I'm just checking that you can all hear me. Okay. My background is predominantly from a contractor side. Okay, great. Just seen a message. So my background is predominantly from a contractor side. I have done a little bit of work from consulting side in South Africa, but predominantly from a contractor's perspective. So the view that I'm going to discuss today is around what, from a contractor's perspective, why we would look at joint venturing with someone. And I'm not sure, there's a terrible feed. Okay, that seems to be a bit better now. So from a main contractor's perspective, I mean, the reasons we would normally joint venture on any sort of project is, one of the main reasons is the magnitude. So the size of a project. Gabriela touched on it earlier, where, you know, we typically, from being a tier one contractor in South Africa, would look to joint venture if a project was in excess of 100 million US, generally speaking. And that's really just because of the size, you know, the magnitude of the risk associated with that project failing or going badly. That could sink your business. I mean, if you had a project in excess of 100 million US that didn't make any profit and lost 10 million US, that could be your gross profit for the whole year of your turnover. And that would put your business into serious risk. If some of the mega projects are complex, there's multi-disciplines, the programs are tight, and therefore you would rely on a partner to assist you with certain complex elements of it. They might be experts in either a slip forming or something like that. They've done this type of project before, which would aid you to partner with them, and they could help you deliver the project. It's also a resource constraint. We don't always have the resources available. It depends on, or all the resources available. It's largely dependent on what projects are live and what we're currently doing. So we would then look at a partner that we could get, you know, shared resources, and that would be from a site management level. The other big thing is location. So location, if we were looking at cross-border from South Africa, or we would look at a partner within that country where the tender is, because they would have knowledge of who the supply chain is, where your labor force is going to come from, and it just makes sense from a strategic point of view to look at someone from within the country that you're tendering on. Strategic, Gabriela touched on this, but this is a very important part of contractors forming a joint venture. If your partner has certain expertise in areas where you're lacking, then you would look to get those expertise within the joint venture. And largely, we wouldn't bring in those expertise as subcontractors because of the complexity. So we'd want to bring those partners on as part of a joint venture. It just creates a little bit of a different environment where the two teams work together rather than against each other. The partner has a relationship with a client. This is also an important one. If our partner has worked particularly well with the client before or has done a lot of work for the client, then we would approach that partner to say that there is a mega project for their client and would they be interested in partnering with you. That just gives us a bit of a benefit or a little bit of an inside lane when the tenders are being considered. And again, like I said, is the partner local to the area. And we'll even partner if within South Africa, even provincially, so even in different provinces, if there are guys, contractors that are based in a different province who have a very strong footprint within that province. Because even the provinces have little micro areas of resources and stuff that are available. And if you are a local contractor to that province, it does aid in getting subcontractors and supply chain on board. Ability to contribute specialized resources, very important. Again, what I said earlier is if we have our internal plant all busy on other projects, then we would consider bringing in a partner who has additional plant. And the reason I say that is in-house plant gives us a competitive advantage rather than going to the market at time of tender, because that we can discount that plant within the joint venture. So the partner's resources are available. Again, depending on, we're very up and down. I mean, depends if we're busy, then our resources are all allocated to projects. And if we're not very busy, then we will have resources available. So if we are busy and we want to go for a big project and we don't have all the resources, then we would look at another contractor to join us to share the responsibility on site and share those resources to be able to deliver the project successfully. Sometimes our partners have other affiliates or other companies within their remit, and they manufacture materials. It could be bricks. They've got specialist divisions that provide construction materials. And then we would bring that in because normally what we would limit there is a profit on profit markup. So therefore making our tender more competitive during that time. This is very important. Most of our joint ventures are joint and several unincorporated joint ventures. So the partnership of your partner needs to be financially stable. For the obvious reasons, if your partner isn't financially stable and for some reason should get into financial trouble, the burden of that project gets put on, the commercial burden gets put on to the other partner. And that makes it very, very difficult. The other important thing is working capital, particularly upfront. And that working capital is basically cash injection. There's costs on a project from day one. And, each partner needs to carry their own costs up to a period of time until work is proceeded in such a manner that the project has actually generated its own cash positive position. But this can take several months, as well as the problem is if projects don't go that well during the duration, if the project is running at a loss, we tend to treat the joint ventures as almost their own sort of entities. They have their own bank accounts, which both partners have access to. Money that comes in from the project goes into that bank account, and any costs that get paid out of that bank account. So if a project is running into trouble, obviously puts you in a bit of a cash negative position, in which case the partners would be required to put working capital back into the joint venture account to keep the project running until its completion. The other thing that we look at is certain partners might have, they're better off financially than we are, and therefore have better buying power. Because they're bigger than we are, and this also helps to give you a bit of a competitive edge at time of tender. So the main risk around being stable is obviously the burden of the reason we didn't want it. The reason we went for the joint venture in the first place was to limit our risk. And obviously, if one of the partners is unstable, then that whole burden gets put back onto the partner that's still carrying on with the project. Then this is a fairly big one, is the required security. So all contracts and clients will require an element of security from a contractor through either performance bonds, retention guarantees, or retention and working capital. If it's cash, then working capital comes into play again. We've been finding it more increasingly difficult particularly in South Africa. I speak from South African point of view, where for contractors to be able to get guarantees from banks and sort of known insurance providers. It might sound like it's simple, but it's not that simple. Because we are viewed as a high risk industry from the banks. And what happens is, as a company, we generate what we call a facility. We go to a service, to a provider, a guarantee provider. They then give us a facility that's normally capped at a value. And then once that value, we can't exceed that value. So once we use all that value, then we are unable to price other work, because we can't provide guarantees should we be successful in getting that work. So on a big project, 10 billion, and it's predominantly 10% or sometimes as much as 15%, but generally it's 10% of the contract value. So on 100 million US, so we would need a 10 million US guarantee, and that could eat anything up to 20-30% of your overall facility, which limits you to get other work. So what we would do then is bring in partners to be able to share that facility. So we would then land up with a 5 million US each, which rather than the full 10 million on one of the main contractors eating into our facility. So really basic from a contractor's perspective, joint venturing is to limit risk, to share resources, share experience, and share working capital, cash back into the joint venture itself. So pretty much that's where it is from the contractor's perspective when we decide. And location is also another important one. So those are sort of the key points that we look at when we want to form joint ventures. And then, okay.
Thank you very much. Very quickly, we'll go to the next member of this panel. Her name is Lois Oni, and she currently works with Gabriela Limited as the lead Counsel of Technology projects and production, and she provides legal services to the company's plant sites and projects. As a legal services provider in LNG, she has worked on major EPC projects, including but not limited to the construction of the NLNG corporate head office and the ongoing mega project, NLNG Train 7. Liz is going to be speaking on problems within JV on African infrastructure, turning insight into foresight. Over to you, Liz.
Thanks. Please, can you confirm you can hear me?
All
right, great. Thank you. And also of course, to the organizers. I mean, it's great to be here and hear these different perspectives in this discussion on what happens when the relationship goes wrong, and particularly whether that's a relationship between the JV and the owner, or between the JV partners, and what you can do to mitigate or forestall those risks, particularly from an owner's perspective. And I think, like an earlier speaker, I think Gabriela had mentioned, you do see JVs on a wide range, from smaller projects to the mega projects, such as what Ryan spoke about, running into billions of dollars. And of course, a lot of the time, the focus is on, ensuring the JV partners are able to make it work. But as owner, obviously, you stand probably, in my view, to lose the most if that relationship does not work. Because you have back-to-back commitments likely, or whatever the JV is doing for you, whatever they're constructing, for instance, it's to give you the capacity to satisfy your obligations to your customers, and you can't say to them that JV just did not work out. Oh, sorry, can you guys see my slides? Just to confirm. Can you see my screen? The slides? Okay, fantastic. Thank you. Okay, so now the project owner, I was just saying, in my view, I think you likely have the most to lose because of your further on, or your ongoing obligations to your customers that you must be able to fulfill. So you have your reputation, you have business relationships, loss of business, and all that on the line. So if you go back to the reasons why the JVs are formed, which Ryan had also mentioned, it could be for a lot of things. Giving you the required technical competence, especially for mega projects, the scale and the scope of work, ability of the contractor to provide that in terms of the scale and scope of work you have, availability of funding, could be regulatory requirements. And these are great qualities which, as owner, you actually need assurance of, because that's what's going to help you, be sure that the project delivery, you can get your project delivered, especially in terms of your quality and the schedule and the pricing, which you will agree upfront. But then the African landscape is a bit unique. The expectation, especially when you're dealing with mega projects, or especially when you're dealing with a consortium or international partners, or partners not even from the locale where the project is being run. You need to have an understanding of the environment. They're going to be social, economic, political, and especially the state of infrastructure. All these things are going to impact, or have the potential to impact, the performance of the project. And it's important that the JV understands this. So as owner, one of the things you want to make sure is that the JV is actively engaged in this, because you're not, as owner, going to be able to manage the relationship, for instance, between the JV and regulator to some extent, or the JV and the community. So you need to have them very well aware and very engaged in this. Now, as owner, it's also important to keep at the back of your mind, right, that the JV is, or that your agreement with the JV, for instance, it's not only an outline of responsibilities and obligations. It's not only a risk allocation tool. It's also an agreement to the final outcome, which is something that you, the owner, and the JV, is like a statement of intent of what you want to achieve. So it's key to have that at the back of your mind, because it really helps in looking at disputes. It really helps in looking at ways of working, and how maybe the failure of the JV or the failure of the relationship can impact or prevent both of you from achieving this thing. And of course, there's several things that could either, promote or reduce the chances of a dispute. And the contracts, very key, can help to mitigate those the risk of that dispute in the JV. Now, if you look at some things which may affect performance, there's always a performance risk, especially where you have the international and local partners, or even when you have on mega projects, you may have to have several international partners form a consortium. Maybe they're even from different regions, and then you can have things like internal conflicts. You can have things like the culture of the different consortiums clashing. You may have control challenges, which JV partner is going to lead. They may have that internal conflict. Where you have a local partner and an international partner, you're likely to find inequality in terms of competence and experience. And then again, you may also have, I think we talked a bit about community issues. I think Gabriela had mentioned that some of the issues could be like having the contracts or the subcontracts. That's very true. And sometimes it's things like homage. They may have particular local customs that contractors coming into the location must pay homage to the chiefs, must pay homage to the community. You must have forced roles, actually, you may find. They must employ a liaison officer, or you might even just have to have a local employment quota, and that must be cleared through some community challenges, community channels. So it's very important that the contractor is part of this process and knows what the local conditions are. And one way you can do this to highlight the importance and prominence is documenting it as part of the contract. It's not enough to assume you get a contract to come and work in this location and come. The community issues can be really, really important there. Cash flow, as with most contracts, cash finances tend to be a bit of a challenge. Upfront, if what you are going to do is to provide some cash upfront, then of course you protect yourself with certain securities like having an advance payment guarantee or the type of guarantees that the parent company guarantee and all that have been spoken to. You can also have a performance bond. Again, it just protects you across the range of risks that you can face. I think that you should also, in the contract, ensure you have clarity around your interface between the parties, between contractor and JV, very key. Also, of course, your variation framework. Claims, you're likely to have a lot of claims. I found it interesting that there are situations where you may have 100 claims and 60 may succeed. I actually remember one of the claims that we had to work on, one of the projects we had to work on, it was running into the hundreds of millions of dollars, and the claims that came in, by the time we had gone through everything, only about 10% of those claims were successful. Again, because it depends on how you keep your records, how you manage the contracts and all that. But yes, you will have a lot of vexatious claims that come in. So you have to be able to manage that as well. Now, one thing that I'm not sure it's given enough prominence, but is very helpful, is notification requirements. As owner, it needs to be clear that where there is a dispute or a challenge or issues within the JV, in fact, in any of the relationships that the JV has, maybe between the JV partners or between the JV and regulators or JV and community or JV and its personnel that can impact delivery of the project, you need to be notified as owner. It helps you to either step in, if you can step in or intervene and support the contractor, remembering that you have the same end goal in mind, or it helps you to know whether you need to be able to cut your losses and put in one of your backup plans. But it's key to keep that notification. I think that's something that owners really need to have. It helps you decide what you need to do next. So I'll mention very quickly too, in terms of payments. Now, payments could be, and I think some of the issues have been mentioned, it could be a cash flow issue. It could also be payment splits. One area which may not also be explored enough is the ability to use split contracts, especially with regards to the scope of work. So first of all, you want to ensure as owner that in the JV agreement, the scope of work is clear to forestall arguments about who's doing what work or whether one party is doing more work than the other and getting more pay than the other. You want the payment splits to also be clear, or payment schedule, and that payment schedule needs to be transferred into the contract, obviously. But if need be, where there's specialist scopes or where the timing for the different scopes is very different, you could consider having split contracts under the one contract. That's another protection you could put in place. And then of course your liability framework, I won't go into that. I think that has also been mentioned. But in terms of counterparty risk, very important as owner to do due diligence on both parties or all the parties to the joint venture, and pass on a requirement to have the that same level of due diligence done on all subcontractors that will work on the projects, especially on the mega projects where you will be getting a lot of international funding, where compliance is key, compliance and sanction issues, ESG, to the type of parties that will be providing funding. You need to have addressed that, apart from basics such as ABC. And very importantly, the best time to get this done, obviously, is pre-tender. It helps you to weed out early enough without putting too much into it, the parties that will not participate or that you wouldn't like to participate. But having said all that, and bearing in mind that, again, you do want the same thing, you do have a project to achieve, the things that you as owner can do to help mitigate the tensions and, of course, support the JV in delivering the project as you wish. First of all, is just do your part. Your obligations under the contract need to be clear. Make sure your payments are timely. Make sure you've provided access to the site and any other deliverable that you need to provide as owner. Please try and do that, in a timely manner and efficiently. Communication is key. It not only helps you to stay in the loop, but helps to develop and improve the relationship with the JV partners. Of course, use data, keep your records. Where possible, drive capacity building. It helps reduce the opportunity for resentment within the JV, and of course in the community as well, because you would have taken on quite a bit of the community workers, employees as part of the labor. It also helps improve the relationship between the JV and the community as well. Your objectivity in handling the parties, being reasonable upfront in your negotiations of the contract, because you will, if not, end up in a situation where one party who really just wants the contract says, we'll accept whatever terms we're given. And then later down the line, you begin to have some problems because either claims or something in terms of performance. And then finally, you need to have a backup plan. If you've done everything you can, provided all the support you can, and it still goes wrong, you need to know upfront what your plan B is going to be. What are you going to do if it doesn't work out? So I'll just summarize by saying the various perspectives have been very interesting. I find that there are a lot of commonalities across the continent, across the employer interests, and across the type of contracts and JVs we find. But the two things that you really want to ensure exist in the relationship within the JV and in your relationship between the contractor and owner, or project owner, is clarity. First of all, you need clarity on everything, and you need that clarity as soon as possible. What that translates to is that you will likely end up using a bespoke type of contract, not necessarily the general template, and it will probably serve you better. And of course, you want alignment, again, between the partners, and alignment as owner with the owner and JV in all these areas. I think I can stop there and hand it back to you. Thank you.
Our next speaker is Mr. Babatunde Fagbohunlu, SCN. Prof, as I like to call him, is a senior partner and head of the litigation and arbitration practice at Aluko Oyebode. He's been recognized in publications such as Who is Who Legal Nigeria. He's been described as a fantastic litigator, and he's noted for his craftsmanship in constructing legal arguments. Prof, over to you, sir.
Thank you very much, Demola. So I'm giving the midnight speech in this session, and so I'll be talking about the midnight clause, and that's the dispute clause. Of course, the problem arises because the dispute clause in the contract between the two joint venture contractors does not avail the owner. So you've got an owner who gives out a contract to a joint venture, and the joint venture agreement has a dispute clause. When things get nasty between the joint venture contractor and they try to resolve that, the dispute clause may or may not work effectively. If it's not working and there is disruption to the project, what does the owner do? The owner cannot avail itself of the dispute clause. So I'm going to be using a case study. This is an actual live scenario of a matter in which I was involved to elucidate the issues and tease out questions about what can the owner possibly do to minimize or mitigate risk when the dispute clause in the joint venture agreement is not working and there's a threat to the project. So in this case scenario, it specifically has to do with a contract. The underlying contract was an EPC contract for a gas pipeline. And the owner of the project had, of course, engaged an EPC contractor, but had also engaged a project management joint venture to supervise the EPC contractor and to assist the EPC contractor. The disputes in this case arose within the project management function, which was a joint venture between two entities. We can have the next slide. The joint venture was an unincorporated joint venture, and that's what you typically see in these situations. Sometimes you see incorporated joint ventures, but it's more often that you see unincorporated joint ventures. Now, as one would expect, the problem that arose had to do with allocation of responsibilities between the JV partners. And I think these are some of the issues that previous speakers on the panel have talked about. So how was responsibility allocated? There was a local joint venture partner and there was a foreign joint venture partner to provide this project management for this EPC contract. The local joint venture partner was to fund local logistics and expenditures, and the cost incurred by the local joint venture partner was to be a first line charge on funds paid by the owner. And the foreign joint venture partner was to perform the engineering design review. Now, as sometimes happen, or should I say often happens, there were project delays by the EPC contractor, and this resulted in cost escalation, even for the project managers. Naturally, there was a lot of sensitivity over how funds that are received will be spent or allocated. Now, when a particular milestone payment was made by the owner, the local joint venture partner, who the parties had agreed would be the one to collect all the funds from the owner, pretty much appropriated all the funds to itself, shortchanging, as it were, the foreign joint venture partner. So the foreign joint venture partner decides to challenge the claims made by the local joint venture partner about the local expenditures it had incurred. So essentially, it called for detailed accounts to be made, more transparency and all whatnot. But also because it was really, really annoyed about the fact that the local joint venture partner had taken all the money, it asked the owner to intervene and stop paying any further funds to the local joint venture partner. And it also stopped work on its engineering design review. So pretty much the project came to a halt. And that is the problem that came to arbitration. On the next slide, of course, I had already mentioned that this was an unincorporated joint venture. So we can move over to the next slide. Now, typically, the types of problems you would see, you could have disputes between the owner and the joint venture, but except for the particular complexities that are introduced by the fact that your contractor is a joint venture, the disputes typically tend to be the same when there are disputes between the owner and the contractor, namely disputes over things like non-payment by the owner, defects, delays, extension of time claims, additional payment claims, liquidated damages claims, typical problems you would see in an owner-contractor dispute. On the other hand, where you have a joint venture partner versus joint venture partner dispute, the problems you tend to see are the ones that I had highlighted in the case study, which are allocation of responsibilities, allocation of risks within the JV, management of the JV operations, governance of the JV relationship, allocation of JV partners, allocation to JV partners of payments received from the owner employer. Now, what then happens is, what tends to be very critical is what kind of remedies does the aggrieved party seek when these types of problems arise? And what kind of dispute mechanism does the aggrieved party use? The answer to these questions tend to be make the difference between whether the project will be disrupted or will not be disrupted. Typically, can I have the next slide, please? Typically, if the aggrieved party limits itself to seeking accounts or damages, you would have no problems with the underlying contract. Those will not delay or disrupt the contract. But what I tend to see in practice in relation to Nigerian projects, and I'm not quite sure if this also happens across the continent, and I'm sure if there are other participants from other African countries can probably contribute to this. But what I tend to see is that the aggrieved party very often adopts a strategy that is calculated to be disruptive so as to get attention. So the aggrieved party wants to get the attention of the owner. Like I said earlier, in this particular case, the aggrieved party requested the owner to stop making payments to the local joint venture partner. Sometimes they actually go as far as getting injunctions from a court to stop the main project from going on. So when there was a dispute, I talked earlier when I was giving my opening speech about the Minister of Works having expressed frustration about the Lagos-Ibadan Expressway contract having to be stalled by a court injunction that was obtained by an aggrieved party in a joint venture. And we see these types of scenarios occurring quite often. So when the aggrieved party seeks an injunction, whether it's interim or whether it's final, or in the case of incorporated joint ventures, if the aggrieved party decides to start a minority action and seeks to wind up the local content, the SPV, the vehicle for performing the contract, then you could have serious problems. Those could import serious problems for the underlying project. On the next slide, the typical dispute mechanisms that are available in this kind of situation. Again, if the aggrieved party decides to do adjudication or dispute board, if those were available under dispute mechanism, then of course there is limited risk of disruption, or indeed, if they seek expert determination or mediation. The dispute mechanisms that probably are likely to disrupt would probably be arbitration if interim orders are also sought to disrupt the project. And I've seen that happen quite a number of times, or if litigation is resorted to. Now, again, from experience, the fact that you have an arbitration clause typically does not mean that an aggrieved party, an aggrieved joint venture partner couldn't be disruptive or will not be disruptive. So I've seen a good number of contracts that have arbitration clauses. In fact, some that have arbitration clauses in foreign jurisdictions, but where the aggrieved party has sought injunctions in the Nigerian court that had the effect of disrupting the project. Many people remember Shell and Cresta. Many people who practice here in Nigeria would remember the cases like Shell and Cresta and all whatnot. So I will go on to talk about the particular solution that was found in this case study, the particular solution that was applied in this case study. And it was essentially, if we can have the next slide, please. It's essentially, and I'm talking about the solution here just to highlight what can go right if you have a good dispute clause. But then I will then finalize by talking about how even a good dispute clause can be frustrated. So in this particular case study, the case went to arbitration, but there was an interim hearing where an interim award was made as to what should happen in the meantime, pending when the substantive claims are had. It was a substantive claim for accounts. The foreign joint venture partner wanted accounts to be taken to pretty much audit the local joint venture partner's claims as to the expenditures it had incurred. But that was going to be a lengthy process. In the meantime, the project was stalled. So the solution that was applied was one in which an escrow account was established for the owner to pay project funds into. And the interim award now established terms on which monies paid into the escrow account could be disbursed to both parties so that they could perform their individual responsibilities within the joint venture. Now, it was a process that meant that a party who wants to draw on the escrow would make a request to the other party. If the other party did not dispute that request, the money is disbursed. If the other party disputes that request, the money would still be disbursed, but against a guarantee provided by the requesting party. And then ultimately, the tribunal will decide whether the request was a reasonable one or not. But the disbursement would happen in the meantime against a guarantee to ensure that there is constant movement on the project. So this was the solution that was applied to ensure that the project could continue, would not be stalled. Now, this was possible because there was an arbitration clause, and there was willingness on the part of both parties to comply with the interim award that established this arrangement. But very often, and if I move on to the next slide, my last slide, very often you will find that, and I have again experienced this, parties that agreed to do arbitration, a dispute arose, they agreed to then first of all submit to expert determination. The experts came to a decision, and one party refused to comply with that decision and did not even go to arbitration, but instead went to a Nigerian court to get an injunction to restrain compliance with the expert's determination. So there's just so far as a dispute clause can get you. I think what that primarily means, and some of the other panelists have talked about it, due diligence at the beginning. It's important to know who your joint venture contractors are going to be, what kind of relationship exists between them, what the potentials for highly disruptive disputes could be between these joint venture partners. Otherwise, adjudication and what I've just discussed, managed escrow accounts, could be a useful tool where the parties are willing to cooperate. Now, a question that I have thought about, and which I think it will be good for discussion, maybe during Q&A, how far can the owner, given that the owner is not a party to the joint venture agreement, how far can the owner seek to influence the choice of dispute mechanism within the joint venture agreement itself? Should the owner seek to influence it, and can the owner seek to influence it? For instance, during the bidding process, is it possible to include as some kind of appendix to the bid documents, some kind of submission agreement to non-contentious dispute mechanisms like mediation, adjudication, or indeed expert determination, for the joint venture contractors to sign up to, so that at least the owner has some degree of comfort that if a dispute arises, then there is a lower risk of parties resorting to disruptive kind of dispute mechanisms like injunctions and litigation. Or can the owner even seek to further buttress that or support that with asking parties to provide guarantees against where disruption occurs as a result of disputes within the joint venture? These are issues which I have thought about and I think might be a good subject for discussion during Q&A. If the joint venture contractor is an SPV, an incorporated joint venture, where you are likely to have, say for instance, where disputes occur and a party goes to court to seek a winding up of the joint venture vehicle on just and equitable grounds, typically that might trigger a termination clause within the main contract itself. That's a contract between the owner and the contractor. And there might well be a performance bond that can be called upon where termination has to occur in those circumstances. But of course, this can be extremely disruptive of projects. Fundamental lesson is due diligence is probably the key to minimizing risks of disputes occurring between joint venture partners in the contractor group. Next best thing is to probably try to ensure that the dispute clause that the joint venture partners agree to is one that minimizes the risk of highly disruptive disputes. Thank you very much.
Thank you so much, Prof. We have a couple of questions online, but we'll just have time. We have just enough time to take one. And I think we have enough time to take one or two contributions from the physical audience, but I think I should start with the online question. I don't know who is best placed to deal with this. And the question is, what are specific best practices in relation to JV on African infrastructure? I don't know who is best placed to deal with that. Studio, please, could you show the two online speakers too, in case one of them wants to contribute to that? You want me to repeat the question? So the question is, what are specific best practices in relation to JV on African infrastructure? And I was also wondering, is there anybody who wants to contribute, who has a question physically? Is the time to speak or remain silent forever? Anybody? Going. Please don't be shy. Or contributions towards props statement. Prof. This is the second prop. Please introduce yourself and your question, sir.
Hi, my name is Bankole Shudipo. I thank you. I want to thank all the speakers, particularly Mr. Fagbohunlu. It appears that you could have another scenario where you have a joint venture owner and two separate entities, and each one has contracts with different parties on a project. Because we had a situation like that, and then one of the joint venturers or owners went bust, and our client was now left in the cold with regards to their fees, because there was no direct contract with the joint venture. So I'd like to hear comments on that. Thank you.
I was going to say that's something very peculiar to have a joint venture owner and to have them contract separately, because the joint venture implies that you want to join as an entity, so you would also contract as an entity. I would assume that that separate contracting came prior to the joint venture coming together. I would assume, did it come prior? Because, and then you would print the contracts into the joint venture. I mean, in that case, I would have recommended for those contracts to be seeded into the joint venture entity owner to avoid that kind of issue.
Yes, yeah, that's correct. And I think the other issue, of course, is whether the joint venture owner was an SPV, an incorporated entity, or it was two separate entities entirely. So there were two separate entities. And I'm not sure if I had the question very well, but did you say that the separate owners had separate contracts with other entities? That's what I heard, yeah. Now, of course, I think that's even, from my perspective, is less of a complicated problem, because there is only privity between one joint venture owner and another entity. So it's a dispute directly between them. It's not a project dispute from my perspective. It would be different if it was that it was a contract between two joint venture owners and one supplier or a contractor, for instance. Now, in that kind of situation, liability is joint and several. So I would have imagined that both joint venture owners would be named as contracting parties, and there will probably be an express joint and several clause in the contract between them. But if there isn't, I think that's something that the law will imply, that liability is joint and several. But sorry, you were going to say something just now. Yes. 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 Right. Yes. Only one entered into a contract, but it was in relation to the oil well. Yes. Certainly, as far as the liability to the service contractor is concerned, I think that the service contractor unless there is some other fact in the matrix that has linked the non-contracting owner to the transaction and that gives the service contractor some kind of perhaps equitable right of recourse against the non-contracting owner. My thinking would be that the only right of recourse the service contractor has is against the contracting owner. It may well then be that there's some kind of indemnity that the contracting owner can claim against the non-contracting owner. But other than that, it's going to be a direct dispute between the contracting owner and the service contractor. That's my perspective, yeah.
If the asset is in fact owned by two separate entities, the entity that contracted would have had to have some kind of authority from the other owning entity to be able to contract. So you'll have to look at, as you said, there must be other facts in the mix. You will have to go back and look at the facts in respect of the ownership of the asset. I had a question for Tunde in respect of your case study. I would assume that you said that there were delays in the project due to I would assume that the dispute took place whilst the project was in suspension, because for the employer to put the money into an escrow account and the JV partner that was in fact still doing the work not benefit from those payments would be quite prejudicial to the project and the JV partner who was still committed to finish the project. So I would assume that whilst the dispute was going on, the project was in suspension, I would assume.
Thanks. The project had gone into suspension as a result of the foreign JV partner's request to the owner to suspend payments to the local joint venture partner. These were project managers, not the EPC contractor. Now, the delays that occurred had been because of the EPC contractor's defaults. And that kind of escalated costs. And that created problems for the project managers who now had to be incurring costs at inflated prices. But the dispute, yes, the contract had stalled because of first of all, the EPC contractors' delays, and then secondly, because of the request by the foreign JV partner to stop paying money to the local JV partner. The escrow was established by the arbitration process to help the project regain traction. And it was established in such a way that if there was a dispute about a request any party was making, there would still have to be disbursement against the guarantee being provided. Yeah. There was another question though about best practice in yeah, so and I can imagine that there will be several contexts. I mean, for instance, there would be best practice, for instance, in your tender process. How at the tender stage do you minimize risk? What are the best practices to minimize risk at the tender stage? I will leave it to people, maybe Lois or perhaps Ryan to maybe answer that.
Lois, I saw your hand up, maybe in 1 or 2 minutes, because we need to go to the next section. Thank you very much.
Thanks. And I think that one key thing that can help minimize the risk is to have site visits, is to insist on site visits or a duo of site visits and then clarification meetings thereafter. So the site visits then enable the joint venture, the contractor, to take a proper view of what is available on ground, what they will need to, provide in addition, and of course then they can then price that in properly. At the same time, you then have clarification meetings where they can discuss further. The owner being being on ground in that locality, you can also then tell them which areas you're able to provide them with support, and it just helps build that alignment and clarity that you're building into the contract.
Thank you so much, Liz. Please, could we put our hands together for this panel? Thank you so much, Prof. Thank you, Gabriela. Thank you, Ren. Thank you, Liz. Please, are you tired? Please, your hands together, please.